Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. This video, we're going to talk about don't let your estate plan go up in smoke. Now, fewer people are creating estate plans today than in years past. Current research shows that in 2024, less than one-third of Americans report actually having a will in place. Now, every adult, whether they're 19 or 99, should at minimum have a will. Many people can also benefit from estate planning documents such as trusts and powers of attorney and advance directives. But even if you have created a comprehensive estate plan, it may no longer align with your objectives if it is not kept up to date. Now, as we get older, it is inevitable that we become more aware of our own mortality. Reflections on life and death do not necessarily have to be morbid. They can also prompt us to take actions that allow us to focus on our legacies. And this is exactly what happened during the peak of COVID-19. Stuck at home and more mindful of health, Americans turned their attention to estate planning, which then led to a surge in the creation of new wills and trusts. But that trend has since reversed since 2020, and the long-term trend is towards less estate planning. Now, studies from caring.com in 2024 found that 43% of adults over the age of 55 have wills. In 2023, that was 46%, and 48% in 2020. So we're on a downward spiral. From 2000 to 2020, the share of people aged 70 or over with wills declined from 73% to 64%. On the other hand, the number of young Americans who have a will has increased in recent years. Around 75% of 18 to 34-year-olds and 35 to 54-year-olds still do not have one. Procrastination is the top reason people give for not making a will. Other common excuses are not knowing where to start and concerns about how complicated or expensive estate planning might be. Now let's talk about why estate plans can fail. The reasons why people do not have an estate plan underscore the more significant point that estate planning can often feel overwhelming and unpleasant. However, not having a plan that addresses what happens to our money and our property after we pass away, and who cares for our children when we cannot, and who will manage our affairs during an emergency while we're alive, among other concerns, puts loved ones in a very difficult position. Now, without a plan, your family may have to turn to the courts for answers, which will likely not satisfy anybody. Disagreements can spawn litigation that pits siblings against siblings and squanders lots of money on legal fees. Now, these issues can also arise when an estate plan is incomplete, inaccurate, or just simply outdated. According to a book written called Estate Planning for the Post-Transition Period, approximately 70% of estate settlements result in asset losses or family disharmony, outcomes that the author attributes to estate planning failures that are within the family's control. Now, an estate plan can fail for many reasons. Some of the leading causes are a lack of follow-through, not informing heirs about the general outlines of the plan, and simply not updating the plan. You might, for example, set up a trust to avoid probate or to manage accounts and property for an underage or a disabled loved one. But if you do not follow through by transferring ownership of your accounts and property to the trust or making the trust the beneficiary, the trust will likely not accomplish your goal of avoiding probate. Now, another common mistake is setting up powers of attorney and medical directives, putting them in a drawer or filing cabinet and not telling anyone about them. These documents authorize others, called agents, to act on your behalf. Some may take effect immediately, while others may take effect only when necessary, for example, during an incapacitation. However, these important tools cannot help you if nobody knows the documents exist and where to actually find them. Now, having an out-of-date plan can result in failures that are on par with having no plan at all. As life changes, the desired beneficiaries of your accounts and property, guardians for your minor children, and agents during your incapacity are subject to change. An estate plan that does not reflect the latest circumstances and your current wishes could lead to unintended and potentially disastrous outcomes for your family. Let's talk about some signs that your estate plan is out of date. An old, out of date estate plan can leave loved ones grappling with many of the same issues caused by not having an estate plan. Loved ones may not be adequately taken care of. Accounts and property could end up going to inappropriate beneficiaries. Your estate may have adverse tax consequences, and you may not receive the end of life care that you want. And your estate could be subject to unnecessary probate proceedings, to name just a few possible consequences. While there's no fail-proof set of rules for determining when an estate plan should be updated, estate planning attorneys recommend revisiting a plan every few years or when there's a significant change in your life, your family's life, or the law. Now, there's a few signs that your estate plan is outdated. Perhaps it was created between 2018 and 2024. The planned expiration of the Tax Cuts and Jobs Act of 2017 at the end of 2025 is set to drastically lower the lifetime federal estate and gift tax exemption amount, potentially increasing the number of estates subject to the federal estate tax and the estate tax liability amount. You wish to modify who receives an inheritance from your estate, the amounts they receive, or the conditions you place on an inheritance, such as instructions for trust distributions. You might decide to make a charitable gift from your estate. A beneficiary, guardian, or agent has died or is sick, or is no longer a proper choice for some other reason, such as developing a substance abuse problem or showing poor judgment. Or maybe a family member has suggested that they might challenge your will as a presently written, and you want to add a no contest clause if recognized in your state that discourages them from doing so, using the threat of a disinheritance. Or maybe your relationship with one or more of your family members has become strained, and you intend to disinherit them or change their inheritance. Or maybe you have concerns about protecting a beneficiary's inheritance from a spouse, divorce, lawsuit, or creditor. Or maybe you or a family member recently divorced, remarried, became a widow or a widower, or even had a child. Or maybe you've acquired or disposed of significant accounts or property since your estate plan was created or last updated, for example, by an inheritance. Or maybe you purchased a new home, vacation home, rental property, or some other type of real estate. Now, these things that I just discussed is not an exhaustive list, but if even more one item applies to you, it may be an excellent time to review and update your own estate plan. Now, there's some guidelines for keeping an estate plan up to date. Agents, beneficiaries, and inheritance amounts and distributions plans constitute the core of your estate plan and should be regularly revisited. Be sure to also remember other details, such as naming backup beneficiaries, agents, and trustees, and adding provisions that allow beneficiaries to replace poorly performing decision makers. Short of changing a beneficiary's inheritance, you can take steps now to prepare them for financial implications of a bequest. Talk to them about how to handle their gift and ways you might like them to spend it. If you have serious doubts about their financial acumen, but still want to provide for them, consider a gift placed in a trust that specifies how the money can be used. Talk to your loved ones now while you still can about the value of your estate and what they can expect to inherit. Transparency will allow them to express their feelings. Tell them about any significant changes to your estate plan that could leave them feeling surprised and hurt and potentially leading to some conflict. Loved ones should also be informed about where estate planning documents are kept and how to access them. Depending on where the information is stored, you might have to visit a bank with somebody to access a safety deposit box, give them the code to a lockbox, or let them know your digital passwords for documents stored on a computer in the cloud. No matter where your records are kept, make sure that your loved ones will have legal access to them after your death. For example, with many banks, a person you designate as being able to access your safety deposit box will no longer have access after you've passed. So you want to talk to your bank about ensuring that your loved ones can access that box's contents even after you've passed away. Now, the only constant in life is change. An estate plan you created years ago is unlikely to reflect your present situation and priorities, and could be almost as bad as not even having one. While you may be tempted to create and update an estate plan independently, online estate planning tools can be another reason why a plan fails, hurting your legacy and burdening your loved ones. So if you need to update your estate plan, please reach out to your qualified estate planning attorney that practices in the state in which you live and have them help you and review your estate plan with you. I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, where we practice effective estate planning for everyday families located in Massachusetts and New Hampshire.